And it's your motion. So go ahead, Mr. Asper.
That's correct, Your Honor. So on Brent and I have a working relationship. We've known each other for, I think, since 2017. So about a little over 3 years. I have many rentals, and he and his team would work on my rentals. We met through a tenant of mine. That's how we first got introduced. So we've had a working relationship for years. Now, Mr. Shea had told me about, he had I think he had 2 or 3 rentals in Romulus at that time, and he told me about them. He was in a financial situation at that time, and I had told him that what we can do is I will purchase them from him. And no, we didn't do any sort of purchase agreement, which it's not, you don't have to have one by Michigan law. We didn't do any sort of deed, but it was just a mental agreement, a verbal agreement between him and I for a while. So then this comes around, I believe it was in November. I can't remember the date, but in November, he told me about the situation. Now, I consider myself a real estate expert. I've done many cases all the way up to the Michigan Supreme Court in a real estate matter. I am a realtor. I'm a landlord. I am a landlord to over 40 families. I have my knowledge. I breathe, eat, and sleep this stuff. So on December 9th, 2020, which I believe I gave a copy to the court, but I did give a copy to plaintiff's counsel, Brittany, at least. And we did there's a quit claim deed executed on December 9th, 2020 between Brent Shea and myself. Now, the quit claim states, that he is giving me 1% interest in the property. Opposing counsel's argument is that you can't do that, and that it's not in recordable form. I've done this in Wayne County, Oakland County, Ingham County, and Monroe County. It's legal. You can do it. You can even add power of attorney if you like. So any sort of argument that it's not legal or not correct is not true. And just because a deed is not in recordable form does not make it legal. That's another point to this. So because I have interest in the property, I have 1%, but it doesn't matter. If I was a beneficiary and Brent was my dad and he died and I got 1%, I'm still on the case. I still have an interest in the property as I do now. So I would please ask this court to grant my motion to intervene, Your Honor.
Response, Mr. Anderson.
Good morning, Judge. And I want to explain why I'm appearing today. First and foremost, Brittany was prepared, willing, and ready to handle this hearing. But there were numerous communications between Mr. Asper and Ms. Barnes. I should say statements from Mr. Asper to Ms. Barnes that I think made my appearance necessary. And I'll address that if the court would like me to. But what I perceive this to be, Judge, is an attempt at the unlicensed practice of law. We filed this complaint on October 15th of 2020. At that juncture, the land contract had been in default. No payment had been received since December of 2019. But Mr. Shea did nothing. He's attempted to rectify this in no form or fashion. We had to work to serve him with this. He avoided service. When he finally appeared during our last appearance, he advised this court he had an attorney, he had counsel, and that counsel would be reaching out to us. But in fact, what he meant was that he had attempted a conveyance, which could perhaps be a fraudulent conveyance under the Fraudulent Conveyance Act. I haven't explored that too much, but I want that to be presented to the court. Mr. Shea is conveying his interest to Mr. Asper in an attempt to allow Mr. Asper to argue on his behalf. Mr. Asper said as much in his argument. Now, Mr. Asper would be doing so without a law license, without the authority to practice law in the state of Michigan. And every single argument that he's put forth in his motion to intervene and subsequent pleadings, Judge, relate to consequences and damages that only affect Mr. Shea. There is not one allegation put forth that Mr. Asper has suffered anything from this transaction. In fact, Judge, he has had nothing to do with this transaction occurrence, nothing, up until, on paper, December 9th, 2020, when this case was already well into play. What concerns me is that Mr. Asper, if we allow him to involve himself in this case, Judge, he has already carried out a series of actions that I consider to be inappropriate and deviate from the objective, which is to solve this dispute between my client and Mr. Shea. Mr. Asper's involvement is not going to assist in that endeavor. It appears as if Mr. Shea is attempting to use Mr. Asper as an attorney, and I can't see this in any other way. That being said, Judge, I don't see how Mr. Asper has any interest here. I don't see how Mr. Asper has suffered any damage here. I don't see how Mr. Asper is related to this transaction and occurrence in any form or fashion. And frankly, if we allow him to be involved, he will put forth arguments on behalf of Mr. Shea, which will be the unlicensed practice of law. So I would ask this court to deny this motion so we can move on to solving the dispute between my client and Mr. Shea. And I would further request that Mr. Shea, if he does have this attorney and he exists, to bring him forward or her forward so we can start negotiating, a resolution. That's my response, Judge.
Anything else you want to say, Mr. Asper?
Yes, I would. I would like to respond. So opposing counsel states that I don't have any interest on the property. Now, he's also stating I'm not an attorney. That's correct. I'm not an attorney. But that does not mean I don't have any interest in the property. Now, it doesn't matter if I was an attorney or not. It doesn't matter when on this case I came in. I have, since we have the quitclaim deed and Mr. Shea has equitable rights to the property, which opposing counsel.
Wait, you did that all after this was already in default and after the action was already started?
No, I didn't even get served when I was supposed to get served, and I did communicate with the counsel. I have screenshots of all the emails, the plaintiffs. I'm sorry, William, and I'm sorry, Judge, and I'm sorry, counsel.
That's okay.
I did try to communicate with them, and they screwed up by not serving me right. They supposed to serve me at my house, and they never did. That's why their cases were adjourned.
Well, they don't have to serve you at your house. They can
serve me
wherever they
wherever.
serve you.
But that was on their behalf. I mean, it was started on the 15th, but they made the mistake of not serving me. That's why it was adjourned by them several times. So I'm sorry to interrupt, but I mean, I just want to state facts here, and that is in record.
Judge, if I can, frankly, a few things I got to state for the record, because Mr. Asper is out here stating affirmations, and I would like to provide the court some of my own legal affirmations. A vendee who has equitable interest in a property cannot deed that interest away. He can assign his interest in a land contract, and that assignment has legal requirements, none of which are contained in this deed. Beyond that, what Mr. Asper is trying to do at the end of the day, if you look at all of his pleadings, he puts forth not one allegation that he suffered a damage or suffered any consequence from this transaction. Now, to address what Mr. Asper said, he quoted me by saying, opposing counsel stated, I do not have an interest in this property.
Well, wait a second. Let me stop you. Here's the problem, Mr. Asper, and you can tell me all day long how you're an expert in real estate. Mr. Shea can only give you what he has. He can't give you something superior to what he has. And so he can't give you, if he's in default on something, he can't make you not be in default. It doesn't work like that.
No.
It doesn't waive, it doesn't penalize the contractual relationship that he has with the plaintiff in this matter. You can't usurp that by making you an intervener. It doesn't work like that.
So, Your Honor, so I agree with you that it doesn't cancel out any sort of agreement that Mr. Shea has with the seller. That's correct.
And it doesn't give you higher rights than he
No.
has under the contract.
And I'm not claiming anything higher. He is giving me a portion of the ownership. I've done this in
But the
multiple courts.
ownership is in default.
Your Honor,
The ownership, hasn't made a payment, so he can't give you some superior right. Well, I'm gonna end this. I'm gonna deny your motion to intervene.
he has
You have the right
equal
to,
Your Honor, please,
Mr.
please,
Asper, let me explain something to you. I'm going to deny your motion to intervene. And then I'm gonna move forward. With that being said, you are no longer part of this case.
We'll be at circuit court, ma'am. Thank you.
You can be at circuit
Oh,
court.
okay.
Yep,
We'll be accepting your decision.
you can do that.
Yeah,
Well,
cool. I asked for an adjournment on this.
All right, now moving forward with Mr. Shea, where does that leave us, Mr. Anderson?
Well, Judge, a couple of things I want to point on the record before I answer your question, and I will. And I
will just for the record note that I removed Mr. Esper from the proceedings because I'm not going to get into an argument with him about it.
There's a couple,
apologize.
and Mr. Shea, I want you to hear this, and Judge, there's a few things I want to point out for the record. Mr. Asper, upon getting involved in this case, has carried out a systematic and intentional act of harassment and threats against my client and my office. He's threatened my associate, Brittany Barnes, with a grievance. And it wasn't a threat I'm going to, it's an affirmation I'm going to grieve you. He showed up at our office on 3 occasions. We're not allowing anybody in our office right now, and he hovers outside of our door. Yesterday, we had to call the police at our office. I had to take him outside and address him directly. He then reiterated to me, he is going to grieve my associate, who has done nothing but an excellent job in this case. So, Mr. Shea, I want to point out for the record, but Judge, and I didn't mention this when Mr. Asper was on the record because I'm going to have to suffer consequences from this man going forward. Mr. Shea, we want to work this out. We want an attempt that is in good faith to resolve the disputes between my client and you. And involving Mr. Asper is inappropriate, improper, and the threats that he carried out against my office, in my opinion, are criminal. This guy is on probation, Judge, or aggravated assault.
I don't know what any of this has to do with our case.
Except it doesn't, and I can appreciate that you're aggravated, Mr. Anderson. I can feel it. You know what I'm saying? But I just denied his motion to intervene. So
Yes.
he's not, as far as I'm concerned, he's not part of this case.
Thank you, Your Honor.
And I just wanted to make that statement just so that there was a record of
No,
what
no, no.
Mr.
And
Asper has
I
carried
can
out.
appreciate that. I can appreciate that. Now, since I denied the motion to intervene, where does that leave us? We're back to,
So we have requested a default entry.
Well,
Sorry, Judge, I didn't mean to interrupt. All right, can I answer the question or?
yeah, go ahead.
So we have presented a default to be entered against Mr. Shea. We also will be filing, if the default is granted, a motion for entry of default judgment. The amount of the payoff that my client is requesting is $34,215.79. Some of the damages or the costs that make up that $34,000, I imagine will be disputed by Mr. Shea.
Well,
So
I
I
don't
think the prudent thing
understand
to
when you filed this, you said that the total amount in arrears was 6,500. How did it go from 6,500 to 34,000?
That's what I want to know.
Yeah,
Sorry, I'm sorry.
that's okay, Mr.
Well, in a
Anderson. I
nutshell,
can't
Your
give you
Honor-
a default in the amount of 34,000 when the amount you prayed for was 6,500.
I would phrase that as an inaccurate estimate that was contained in our initial pleading, Judge. And there's no other way I can answer
But
that
except
question
that
now.
here we are, Mr. Anderson, and that's what you asked for. If he would have paid the 6,500 back, then, I mean, you can't.
I would have did that too.
Times
I
it
didn't-
6 or 7, please,
Mr. Shea,
Mr.
let's-
Shea.
I'm sorry. I'm sorry. Let me know when I can speak. I'm sorry, Your Honor.
Judge, I would assess it this way. If we do not correct the amount that's contained in the initial pleading, essentially what we would be forced to do is immediately file another land contract forfeiture. And if that's what the court wishes us to do, we could do
Well,
that.
I mean,
Or I can
when
amend my
you have,
complaint
no,
as-
I don't think sitting here today that you can turn around and say, I know we paid for $6,500 and that's the pleadings. And we want to amend the pleadings to jump it from 6,500 to 34,000.
I would beg to differ, Judge, and we do point out issues that these numbers come from. We point out the fact in our initial complaint, insurance wasn't paid. We point out the fact that property taxes were
You
not paid.
tell me from, okay, so you're telling me that back in August of last year, when whoever signed this, I don't know who the person is that signed on behalf of this. Is that your
The original
signature?
forfeiture notices, are you talking
Yeah.
about the forfeiture notice?
Yeah, the complaint for possession after land contract forfeiture.
That's signed by an associate in our office, Brittany.
Okay, so the last payment was in September 2019. They said the original, you're asking for more money than the selling price in the
Yes.
first
And let me
place.
explain-
So the selling price was 30. You haven't made a payment in a year. Your principal balance says that it's 6,300. I take it that you're telling me it's just all wrong.
No, actually, that number 6,300 is accurate when you're considering only unpaid interest and premiums. Now let me.
And then it says total amount in arrears, 6,543.
Yes, and that is arrears only talking about principal and interest, Judge. Now
No.
hear me out on this.
That's not
Mr. Shea has not paid any property taxes. He's required to do so under the land contract. He failed to pay any
No.
taxes in 18, 19, and 20. He hasn't paid any property insurance. He's
haven't.
required to do this.
What,
Mr. Shea,
Mr. Shea,
he's
please.
required to pay property insurance. He owes 938 from
Well,
2019.
here's the problem here's the problem. The way that I see it, when you file a land contract, you have a number and they have so many days to redeem, correct?
I agree with you, yes.
And within this, because it was, according to your own records, the redemption was, the amount to redeem was less than 50 they paid more than 50% according to this. Then the redemption period is 180 days,
Yes.
correct?
Yeah, I agree. I agree.
And so now, and I would give you leave to amend. If I give you leave to amend, the time is going to have to start ticking again, because you can't change the number and not reopen a window for redemption.
And Judge, I don't disagree with you. So I acknowledge the error on our part in filing and not including the appropriate number in.
But I don't want the number just written down. I want if I'm going to give you the ability of leave to amend the complaint, I want a itemized list of where the total amount is coming from.
Yep.
And then I don't know under law, because the selling price was 30. I still imagine if you're saying that there's due and owing more than the original price, it goes back to a 90-day redemption period is what I would think. I'd have to look that up, but I'm pretty sure that that's what it goes to.
Okay,
Do you
And
understand what I'm saying?
yes, because, and I think the logic behind that is in the land contract, the taxes and the insurance, once unpaid, roll into the unpaid balance, thus increasing the amount owed, which could potentially put him under the 50% threshold.
Right.
Still wouldn't.
And Judge, I will, if I'm hearing you correctly, we will amend our complaint. I will provide an updated notice of forfeiture, giving him 15 days to correct the accurate arrearage. Subsequent to those 15 days, we will file a motion, or perhaps we'll just come back for a status conference or settlement hearing, and you can ask of Mr. Shea where he is as far as paying off that arrearage, and maybe just set a trial date so we can just put on the record our arguments as to what the arrearage is and enter a final judgment to pull the redemption period.
And Mr. Shea, do you understand that, in my opinion, I think that you should try to work with Mr. Anderson in the meantime to work it out.
Yes, will I be able to have a chance to talk here? on
Yeah,
some-
go ahead. Go ahead. You
Okay,
can right
well,
now.
All right, well, I was supposed to be given, for number one, I was supposed to be given that 6 months redemption time from the beginning. I mean, actually, that's after I think your ruling is the redemption time, isn't it? So,
Yes,
well,
yes.
Mr.
And we're gonna
the-
give you the redemption period. When he does the whatever, you'll have the redemption
Yes,
period.
ma'am. But the thing is that the property is still mine right now. And
Yes.
the owner, Mr. Borer, Bob Property LLC or whatever, changed the locks in December or last January or a year ago. So he changed the locks right away to where I couldn't even make money off the property. He never gave
What
me
is,
my,
what is the, is it a how, what is it?
it's a single family house in the Meadows neighborhood off of Leroy Street. And he came and changed the locks before the like, he's not, that's illegal. I'm sorry, I'm not I'm not a counsel, but he changed the locks and then he didn't even offer me an opportunity to grab. I had a fully furnished house, towels, everything, detergent. I had tools in there because I was trying to get the house ready to rent so I could pay some of these rearages. And he locked the house up. He's had possession of this house for 12 months.
Mr. Anderson, I mean, that's a problem if that's
And they
true.
admit to
Wait,
it in their
Mr. Shea,
paperwork.
Mr.
I'm
Shea,
sorry.
stop, please. Mr. Anderson,
Sorry.
has he been locked out of the property for the past year?
Judge, no, and here's why. No, Mr. Shea, you had your moment. Let me address this.
Well, wait, you look at your document. It admits it on your documents that
I'm not refuting the fact that the locks have been changed. What I'm going to state, though, is
on the 20th of last year.
Mr. Shea, please,
Okay,
hold on.
I'm sorry.
It's okay.
Judge, in the state of Michigan, a vendor and a vendee create that relationship through a land contract. That land contract controls the relationship. If the land contract allows for peaceable entry, a vendor can execute what's called a common law forfeiture. The case for this is
Don't even go there. Don't
Judge,
even try to
Judge,
start
please.
with me saying that he can lock him out.
Judge,
and do a
you gotta let me
forfeiture.
make
I'm
my
not
argument,
buying that.
I understand, but let me make my argument.
That
please,
law
for
was
record.
changed in
Mr.
1979.
Shea,
Mr. Shea,
please.
Judge, I'm going to make this argument. Please let me put my 2 cents on the record. The case is A.V. Lachey 175 Mishap 363. I have argued this before. I have won on this point before. If there is a notice of forfeiture provided to Mr. Shea, excuse me, the vendee, and the vendee is not in possession of the property as we have in this situation, the vendor can regain peaceful possession of the property. That's what happened in this case. Now, under those circumstances.
You know what, Mr. Anderson? This isn't for today anyway. I denied
isn't.
your
I
the
don't
motion
think
to
it is.
intervene. But at trial, you can make your argument at a hearing. Do you know what I mean? Which is not today.
Yes, but Judge, I want to make a point out here. Mr. Shea has not paid any money on this property since December of 2019.
That's right.
Well-
And there's a land forfeiture that says that you serve him notice, but a constructive eviction, which is exactly what I perceive that to be, is illegal. But you can make your argument on why it's not when you file again.
All right,
And
and I,
supply the documentation.
I will do
It
so,
says
Judge.
that you can lock out somebody and I'll look at it.
You know, Judge, I have to admit, when I found this case, because it came up in another case that I had, and I had a very unruly client that didn't want to provide a redemption period. And I told this guy, there's no way that the law doesn't allow this. But in doing this research, surprisingly, in the state of Michigan, there is what's called a common law forfeiture, and you are allowed to regain possession so long as the vendee does not have possession of the property and they've been notified of the forfeiture, which is exactly what we have in this case.
Well, no, that's not true.
No.
He wasn't notified. Stop, Mr. Shea. I swear. Please stop. Except that if it's been a year, he wasn't notified of the forfeiture. We didn't get the paperwork until August. So that was before he was notified of the forfeiture. So your client didn't do it appropriately, even if that is the common law.
Well, we would, I mean, I would disagree with you, Judge. We did, Mr. Boyer, the vendor, has sent numerous notices to Mr. Shea.
And you can
requesting-
supply all those
And we will.
notices when we redo. You go ahead. I'm going to make a note that you're going to submit to amend the pleadings and then we'll go from there.
Ideally, Judge, I would like to talk to Mr. Shea about just entering a consent judgment so we can avoid all this.
No,
Well, but Mr. Shea, I want you, I'm gonna put you in a breakout room with him. I want you to at least talk to him. Do you
okay, I
understand?
will, but okay. Yes,
Thank
ma'am.
you, Judge.
Yeah.
Thank you, Your Honor.
Yep, hang on a second.
And Judge, I do apologize about the wackiness that this case is going. We're gonna do our best to put it back on a,
That's
back-
fine. Don't, it's not a problem. It is what it is.
yeah, but it is kind of a problem, to be honest.
All right, let me get these breakout rooms back in. Hang on one second. All right, if you both just hit join. Hang on one second. Okay, go ahead.
Thank you.
Yep,
Thank you.